Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 20 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between October 27th, 2020 and November 3rd, 2020. Today we're focusing our analysis on criminal law cases. In the case of Commonwealth v. Clemens, the defendant appealed a DUI conviction on sufficiency and weight claims. The underlying facts are as follows. The defendant crashed his car into a light pole in a truck stop parking lot. An employee found out about the crash and the defendant advised her he had driven into the pole. The employee smelled alcohol and said that the defendant was unsteady on his feet, so she called the police. The defendant claimed that the defrosters on his car weren't working and that he couldn't see clearly, and that is why he crashed. When the trooper arrived, he saw that the light pole was clearly marked. He detected a very strong odor of alcohol and observed an open container that was about a quarter full in the passenger compartment. The defendant was uncooperative and refused to get out of the car to perform sobriety tests. Ultimately, the defendant had to be tased in order to remove him from the car. He was arrested and refused a blood test. The defendant claims that the Commonwealth failed to present sufficient evidence to sustain the DUI conviction. He also raises a claim that the Commonwealth failed to present sufficient evidence to sustain the resisting arrest conviction. The basis for his argument is that no one saw him driving and that while the trooper noted an odor of alcohol, there was no evidence of slurred speech or glassy, bloodshot eyes, other common signs of impairment. The court found that the Commonwealth did present sufficient evidence to support the conviction. The evidence that the defendant admitted to driving into the pole, he had difficulty with his paperwork, he was uncooperative and refused to perform field sobriety tests. There was also an odor of alcohol and a 25-ounce can of 8% alcohol in the passenger seat that was only about 25% full. The court found that this evidence supports a finding beyond a reasonable doubt of all the elements of DUI. In regards to the evidence presented to support a conviction for resisting arrest, the court also found that the evidence was sufficient. The court specifically stated that an officer does not have to use the specific word arrest, as it would have been clear to a reasonable person that he was being arrested. The defendant also argued that the verdict was against the weight of the evidence. When challenging the weight of the evidence, the trial court verdict will only be overturned if the verdict is so contrary to the evidence as to shock one's sense of justice. Here, the court found that the evidence supported the verdict and that the verdict did not shock one's sense of justice. There are no major takeaways from this case, but to note that all DUI cases are extremely fact-specific and that a challenge on sufficiency and weight is a mighty challenge. It is rare to see a case overturned on a weight or sufficiency challenge. Commonwealth v. Lynch is an appeal following a conviction for several drug-related charges. The defendant appealed, raising several sentencing issues, an argument regarding the admission of a recorded phone call, and challenges of sufficiency and weight. The underlying facts of the case involved the defendant directing his girlfriend to travel to Philadelphia to purchase drugs that the defendant would then sell. Two other parties also became involved in the drug ring. These two would buy drugs from the defendant and then sell them to other parties. After the defendant was found guilty at trial, he was sentenced to 201 to 960 months of incarceration. The defendant appealed. The first issue raised challenges the sentence imposed. In order to address discretionary aspects of a sentence, the court must find that the defendant filed a timely notice, preserved the issues, included the appropriate statement in his brief, and set forth a substantial question. The first three prongs are established, and the court must find if the defendant raised a substantial question. A substantial question exists when the appellant makes a colorable argument that the sentencing judge's actions were either inconsistent with a specific provision of the sentencing code or contrary to the norms underlying the sentencing process. The defendant argues that his sentence was above the standard range without considering other factors. The trial court stated that it did not find the standard range to be appropriate and explained its conclusions. The Superior Court finds that this does not raise a substantial question. The next issue raised is that the trial court erred in sentencing him to two separate counts of conspiracy. The conspiracy statute provides that if a person conspires to commit a number of crimes, he is guilty of only one conspiracy, so long as such multiple crimes are the object of the same agreement or continuous conspiratorial relationship. The court found that the evidence established that the defendant initially began selling heroin by having his girlfriend travel to Philadelphia to purchase heroin, which then evolved to include the other parties. This constituted one conspiracy to commit possession with intent to deliver. A separate and distinct conspiracy to exchange stolen or illegally obtained property for financial gain developed with all parties involved, as evidenced by the O sheet. As the evidence supported two separate conspiracies, the court found the argument meritless. The next issue raised was that the trial court should have merged the offenses for purposes of sentencing. Merger is appropriate where crimes arise from a single criminal act and all of the statutory elements of one offense are included in the statutory elements of the other offense. Merger is not appropriate here as all of the elements in one offense are not included in the elements of the other offense. Finally, the defendant argues that the Commonwealth engaged in trial by ambush for failing to turn over a recorded phone call until right before trial. The court found that the defendant failed to specify how his trial strategy would have changed had he been presented with the recording earlier. He knew that the call existed, and as he was a participant of the call, he knew what was said. There was also a jail phone call that took place during trial, which the Commonwealth introduced to attack the defendant's credibility when he was testifying. The court found that by failing to specify in the record which portion of the call was played and by failing to request a curative instruction, the argument is waived. As all of the defendant's claims fail on appeal, the verdict is affirmed. In this case, there is no groundbreaking law change or changes in policy. This case simply serves as a reminder of the importance of preserving issues on the record. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
In the case of Commonwealth v. Jones, Jr., the Supreme Court considers whether opinion testimony from a detective concerning the behavior of a child victim's response to sexual abuse, informed by that detective's training and experience, constitutes lay or expert testimony under the Pennsylvania Rules of Evidence. The underlying facts of this case are several instances of sexual abuse by the defendant against the victim, beginning when she was 13 years old. She did not report these assaults until she was 17 years old. The primary focus of the defense at trial was discrepancies in the victim's recounting of events in an attempt to undermine her credibility. The detective offered an opinion at trial that child victims often have trouble remembering each and every event. The defense objected, but the testimony was allowed. The defendant appealed to the Superior Court. The defendant's argument on appeal was that the court abused its discretion by allowing the opinion because that evidence constituted expert testimony not within the scope or knowledge of the average layperson, but is rather based on the detective's specialized training and experience concerning child victims' responses and behaviors to sexual assault. The Superior Court held that such testimony constituted permissible lay opinion testimony because it was based on information within the detective's personal knowledge and experience, and it was helpful to the trier of fact, and was not based on scientific, technical, or other specialized knowledge. In a dissenting opinion, Judge Strasburger opined that it should be expert testimony. Section 5920, the statute that authorizes expert testimony specifically in such cases, classifies such knowledge, when acquired through experience, training, or education in criminal justice related to sexual violence, as specialized. Judge Strasburger argues that Section 5920 overrules previous case law that does not require or permit expert testimony. On appeal to the Supreme Court, the court must analyze the rules of evidence in regards to lay testimony as compared to expert testimony in conjunction with Section 5920 and prior case law. Lay testimony, pursuant to Rule 701, is that which is based on the witness's perception, is helpful to understanding the witness's testimony or determining a fact and issue, and is not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Rule 702 defines an expert witness as a witness who is qualified by knowledge, skill, experience, training, or education. This witness may offer an opinion if the expert's scientific, technical, or other specialized knowledge is beyond that of the average layperson. The expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue, and the expert's methodology is generally accepted in the scientific community. In this case, the court found that the detective's testimony was based on specialized knowledge or training beyond that of an average layperson, and therefore falls within the realm of expert testimony. In determining that this is in fact expert testimony, the court must then determine if its admission was harmless error. The court stated that whenever there is a reasonable probability that an error might have contributed to the conviction, the error is not harmless. Here, the court found that the error was not harmless and the defendant is entitled to a new trial. The court goes further to evaluate the status of previous case law, which was the precedent before the enactment of Section 5920. The court held that prior precedent in the Dunkel case remains valid insofar as it precludes expert testimony concerning victims and responses and behaviors that touch upon witness credibility, but declined to find that the case categorically precludes expert testimony concerning victim behavior in response to sexual assault. Whether the detective's testimony touches on credibility or not is a question for the trial court to consider on remand. The important consideration for this case is that when it comes to sexual assault, an officer's training and experience is specialized knowledge, and therefore he or she must be qualified as an expert to render an opinion based on that knowledge. However, if the opinion is in regards to credibility, expert testimony is prohibited. This means that if the officer wants to offer an opinion as to the behaviors of sexual assault victims as it relates to their credibility as a witness, that testimony falls under the requirements of expert testimony. However, that expert testimony is prohibited, and therefore the officer, even if qualified as an expert, will not be permitted to offer an opinion as to the credibility of the witness. In the matter of Commonwealth v. Derrickson, the court addresses the legality of a maximum sentence of life in prison for a second-degree murder conviction of a juvenile. In this case, the defendant shot and killed the victim when attempting to rob him during a drug deal. The year was 1994, and the defendant was 17 years old at the time. He was convicted of second-degree murder at trial and sentenced to life in prison without the possibility of parole. Following his conviction, he filed several post-sentence motions and post-conviction relief motions, all of which were denied. In 2012, the United States Supreme Court in Montgomery v. Louisiana and Miller v. Alabama found that a life sentence without the possibility of parole for juvenile offenders was unconstitutional unless certain factors were established. The Miller court set out factors to consider, specifically considering whether the juvenile was incapable of rehabilitation. The defendant filed a motion consistent with these opinions seeking resentencing. His motion was granted and he was scheduled for a resentencing hearing. At the hearing, he was resentenced to 30 years to life. The defendant filed a post-sentence motion which was denied by the sentencing court, leading us to this instant appeal. The defendant raised the following issues: whether a mandatory maximum sentence of life in prison was unconstitutional for a juvenile offender, and whether the sentence in this case was illegal by failing to be individualized to him and for failing to consider certain factors set out in the Miller case. Title 18, Section 1102B of the Pennsylvania Crimes Code sets a statutory mandatory maximum sentence of life in prison for a conviction of second-degree murder. The courts have found that the Montgomery and Miller cases only make a mandatory sentence of life without parole unconstitutional, not a maximum sentence of life. The court has and continues to hold that it is not the term of life imprisonment that makes the applying of Section 1102B to juvenile offenders unconstitutional. Instead, it is the mandatory nature of that punishment when Section 6137A3, which prohibits parole, is applied that raises constitutional concern. Juveniles must be sentenced to a maximum period of life imprisonment. However, they are eligible for parole after a term of years as specified by the trial court. Regarding the Miller factors, the court found that they need only be considered when a possible sentence of life without parole is being considered. Such is not the case here, and as he was sentenced to 30 years to life, so that argument is without merit. In his final argument, the defendant argues that the sentencing court abused its discretion when it considered the breadth and seriousness of his record more than any other factor. In a review of the sentencing transcript, the Superior Court found that the court properly considered his record, as well as the seriousness of the crime in conjunction with his character and efforts at rehabilitation, and there was therefore no abuse of discretion. The important takeaway from this case is that when sentencing a juvenile offender convicted of second-degree murder, it's key to remember that a maximum sentence of life in prison is required, but that mitigating factors can and should be considered in determining a minimum sentence. There were several other cases decided this week outside of the criminal realm, but for brevity's sake, they are not addressed here. The full text of each case, as always, is linked in the comments. Thank you again for listening to the podcast. We hope you learned something this week, and go out and have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.